Hello class, we're going to continue in this video. This is the part 5 in our series for chapter 40, and in this last part we're going to look at other shareholder rights. I'm going to take a moment and switch out to my PowerPoint. Here it is, and let me put it into slide presentation mode. There it goes. All right, so you remember in this chapter we've been looking at the various people involved in a corporation and its operations, its governance. We have spent some time on the directors, taken a look at briefly at the officers. In the video right before this one, we talked about some of the shareholders' rights in connection with their shares and voting those shares. So in this last portion, we're just going to look at a few different rights that shareholders have. So we're going to start off by looking at preemptive rights, and preemptive rights are connected to the ownership of the shares. Preemptive rights applies only to the situation where a corporation will be issuing new shares, offering new shares for sale. And if that's the case, a current shareholder whose interest in the corporation might be diluted by these new shares that are being sold, the current shareholder may have a right to purchase his or her proportional interest in these newly issued shares. If he or she has those rights are called preemptive rights, right? And so as you can hear, it protects the shareholder's interest in the corporation. And this is really important when we have a shareholder in a closed corporation where there's only a few shareholders and maybe they want to retain the interest, the voting interest that they have. They don't want to share that interest with any other shareholder. So if that's the case, then they need to make sure that they're allowed preemptive rights. Now, preemptive rights in some jurisdictions is automatic, and it'll be included in the bylaws, automatically. In California, however, we have a different position. All right, we grant preemptive rights, but only if they are stated in the bylaws. So that means it's an active choice, it's a proactive decision that the shareholders in primarily a closed corporation, that they agree that they will have preemptive rights. All right. So you got to remember, depending on the jurisdiction, preemptive rights may be automatic. Continuing, we're going to look now at Roman numeral 7. Roman numeral 7 is talking about possible shareholder litigation. One of the major things to discuss here is the shareholder derivative suit. Once in a while, you'll read about a shareholder derivative suit in the newspaper. There'll be, usually it's in a Delaware court, a group of shareholders that sues the corporation because they feel like the board has not done a good job at governing the corporation, made a mistake of some sort. All right. So you can think of a shareholder derivative suit as a lawsuit brought by the shareholders against the directors or maybe even other people, but a lot of times it's against the directors. They bring this lawsuit on behalf of the corporation for injury to the corporation. All right. So it starts off with a written demand on the board of directors. All right. Just as all lawsuits kind of start out that way, a written demand to the board to, hey, address this injury that we're pointing out to you. Go after the director who's done something and now cost the corporation a lot of money. We want you to get that money back. That's kind of the idea in the demand. All right. Now, why is it the shareholders have to do this? Because that's really within the purview of the board, right? To look after the corporation and its financial standing and things like that. Well, the shareholders have to do this because the directors have failed to act. All right. The directors they probably do know about the problem. They probably do know about the loss or the injury. All right. They may even have caused the injury to the corporation, and for that reason, they don't want to sue and endanger themselves, risk their own assets and the like, right? So they kind of stay quiet about it. The shareholders, though, learn about this and they can take an action against the board and force the board to track down that injury and get compensation for that injury. That action that the shareholders can take, that's what we call the shareholder derivative suit. Right. Any damages that the shareholders obtain through the shareholder derivative suit, these will be paid to the corporation, not to those litigating shareholders. So it's paid to the corporation, and it's paid despite the fact that even the party that may have caused the injury, that party may still benefit because they might have shares in the corporation too. All right. So there's a little bit, I don't know, is the word irony here for this. Shareholders bring the lawsuit, they get an award. The award comes to the corporation and it benefits the wrongdoers. It can benefit directly or indirectly the wrongdoers. All right. This is our last section of the chapter. So we'll continue looking at some areas where the shareholders may have some liability. So I'm just naming off 3 different areas for you. So letter A, stock subscription agreement. If the shareholders have signed a stock subscription agreement, meaning in advance of purchasing shares, they have promised to buy a number of shares, right? They need to fulfill that under contract law, all right? And so if they fail to buy all the shares that they agreed to buy, then there are some contractual remedies, damages that are available. All right. All right. Letter B, the illegal dividend. If there is an illegal dividend, then the shareholders are liable to repay that money to the corporation. All right. So what would comprise an illegal dividend? An illegal dividend would be the type of dividend that is either paid at the wrong time. So maybe when the corporation is not doing well financially, shouldn't be issuing dividends, they're insolvent, all right? Or if the dividend is paid from the wrong corporate funds, so from the wrong account. Because, dividends should be paid from the profits, not from any other accounts on the books, right? So if the dividend is drawn or ordered at the wrong time or from the wrong funds, it's classified as an illegal dividend. And so what's the consequence of that? Well, the shareholder who has received that illegal dividend is liable for the amount and can be ordered to return it to the corporation. All right, so illegal dividend. All right, the third point here, just want to talk about briefly, is watered stock. A shareholder might be responsible, liable for watered stock. First of all, you got to know what watered stock is. Watered stock is stock that has been issued for less than the market value. Now, you might ask, how does that happen? Isn't a dollar a dollar? If $10 worth of stock, if someone doesn't pay $10, we would know right away, right, that they have not paid what the value of the stock is. All right. This would happen not so much in a cash transaction, but it would happen when a shareholder is going to pay not in cash, but in kind, going to use their services perhaps, or even property that is maybe undervalued or overvalued, or something along those lines, right? Probably when it's overvalued. And so maybe the land is thought to be worth $500,000, and so that's what the shareholder brings and receives $500,000 worth of stock. It turns out, however, that maybe the property value was less than that, only $400,000. Could be they miscalculated the acreage, or they just made a mistake in the valuation, the appraisal, all right? But it turns out that the property is worth less, okay? And that means the corporation who took the land in kind, right, has not received the $500,000. So they may have received only 80% of that. Who's responsible for that difference, for that 20% difference? The shareholder who bought the stock. And that shareholder will be personally liable for that difference. All right, this brings us then, I believe, Almost. Sorry, I spoke a little too soon. All right. This brings us, this I think is the last slide. We're going to look at the majority shareholder. All right. The majority shareholder is a shareholder who pretty much has control over the corporation. Not because they necessarily have 51% of the shares, but even just a very large shareholder. Sometimes in a big corporation, if you own 10% of the shares, you may have de facto control because there's no other shareholder that can outvote you, no one shareholder, let's just say. All right. So if you are a majority shareholder, you have de facto control. All right. You have a fiduciary duty to the corporation to act responsibly and to make good decisions, to vote your shares properly at shareholder meetings and such. All right. So majority shareholder does have liability for their breach of fiduciary duty. The case your book presents to you is this Brody versus Jordan case. It's a 15-year-old case. All right. And what it describes in this Brody versus Jordan case is an oppressive majority shareholder. All right. Someone who exercised control in such a way that it prevented the minority shareholders from participating. They couldn't vote. They couldn't sell their shares, things like that. So oppressive conduct. And the court concluded that all that conduct together added up to a violation of the majority shareholders' fiduciary duty. And I believe the case may have ended up with the court ordering the majority shareholder to pay out and make the purchase of the shares that had been asked for by the minority shareholder here. All right. But the point here is that a majority shareholder should act responsibly and honor their position in the corporation. All right. Now, to end out chapter 40, I want to take a look at this reviewing problem. This is a problem that comes at the end of the textbook. And prior to making this video, I had typed it into the slides here to make it easy to access. I want to make sure, though, that you all know where to find these problems. I don't want to just keep referring to them. So I'm going to go out to the textbook right now. Let me see if I can get it up here on the screen. All right, here it is. All right, so chapter 40, this is what we're finishing out. And chapter 40, if you look at the table of contents here, you'll see all the different topics we covered in this chapter. And so you'll have where the reading is for each of these topics we have discussed. The reviewing problem is always towards the end of the chapter. It's right here under chapter review. Here is the reviewing problem. I'm going to link out to it. You can see it there, and we'll just work with it in the video from your textbook. So let me read to you the kind of longish paragraph, 2 paragraphs. All right, so David Brock was on the board of directors of Firm Body Fitness, which owned a string of fitness clubs in New Mexico. Brock owned 15% of the Firm Body stock and was also employed as a tanning technician at one of the fitness clubs. After the January financial report showed that Firm Body's tanning division was operating at a substantial net loss, the board of directors led by Marty Levinson discussed terminating the tanning operations. Brock successfully convinced a majority of the board that the tanning division was necessary to market the club's overall fitness package. By April, the tanning division's financial losses had risen. The board hired a business analyst who conducted surveys and determined that the tanning operations did not significantly increase membership. A shareholder, Diego Pineda, discovered that Brock owned stock in Sunglow Inc., the company from which Firm Body purchased its tanning equipment. Pineda notified Levinson, who privately reprimanded Brock. Shortly thereafter, Brock and Mandy Vale, who owned 37% of the Firm Body stock and also held shares of Sunglow, voted to replace Levinson on the board of directors. Using the information presented in the chapter, let's answer the following questions. All right, here's our first question. What duties did Brock, as a director, owe to firm body? All right, so what duties have we learned about? I'm going to kind of grab my other laptop so I have easy access to my notes. But what duties have we learned about in this chapter? Duty of care and the duty of loyalty. That's correct. All right, so those are the two duties that Brock did owe. All right, let's move on. Look at number 2. Does the fact that Brock owns shares in Sunglow establish a conflict of interest? Why or why not? All right, so you see what's going on here. Brock is a director at one company, right? He's a director at Firm Body, and he's also has stock in this company called Sunglow, which Firm Body has purchased its tanning equipment from. So what does that, which duty are we talking about here that could have been violated? It's the duty of loyalty, right? So does the fact that Brock owned those shares establish a conflict of interest? Yeah, it does. All right, because what happened? I believe the facts tell us. Sorry, I'm looking off here at my other laptop, but that he voted for Firm Body to buy the equipment from Sunglow, and if that was the case, it is the case that he has a conflict of interest. How should that have been handled? Right? His ownership should have been disclosed to the other members of the board. And what did we learn about his voting? He should have abstained from participating in the decision. All right? So that's how we would look at number 2. All right, let's take a look at number 3. Suppose that Firm Body brought an action against Brock, claiming that he had breached the duty of loyalty by not disclosing his interest in Sunglow to the other directors. All right, what theory might Brock use in his defense? All right, so this might be a little tricky for some of you to think about, but what could he possibly say in his defense here? There's not too much, I don't think, because he has violated the duty of loyalty. But he might be able to argue that, well, even if he did not disclose fully, and even if he did participate, maybe there's not been a lot of damage or any damage at all to the Firm Body Corporation. And so for that reason, then, he defends himself. There's been no loss. All right. And maybe he could also argue that he doesn't own that much in Sunglow, so how much does he really make? He's not really, making any money. I don't think those defenses are really strong, but they're possibilities. All right. That's all we're looking at. What kind of possible defenses? All right, and then the last question, number 4. Now suppose that Firm Body did not bring an action against Brock. What type of lawsuit might Pinata be able to bring based on these facts? All right, so if you recall this last section, we've been taking a look at what can a shareholder do if the board does not act when there is an injury that has occurred. All right, so do you remember the type of action that we were just talking about that Diego Pinata could bring? If you recall the shareholder derivative action, you are correct, right? That would be the type of lawsuit that Pinata could bring if Firm Body does not take an action against Brock. All right, this brings us to the end of the chapter, and I hope that I've clarified some points for you here. I want to take a moment before I end the video to just point out to you, sometimes I forget to do this, but hopefully you have had a chance to look through what I put up in the modules for you. With each chapter, you should see not only a link out to the chapter to read, but also a set of videos. And I know right now what you're looking at, it's not been published yet, but I'm getting ready to publish it for chapter 40. But right underneath the videos, this is generally the place I put it. I'm trying to open this up for you. I have created a list of terms. I have identified the terms from the textbook that I want you to learn in connection to the chapter. All right, so This is just a way of communicating with you in class. If we had a physical class, I would normally at the end of the chapter, go through the list with you. But since we are all online now, I had to publish it this way. All right. So do not forget, okay, do not forget to check this list to make sure you understand each of these terms. You know how to use these terms. If you need a little help with the terms, let me go back to your textbook. I don't remember if I've shown you this, but just to mention to you, there are some supports, these study tools over here on the side. Let me see if I can scroll down. Oops, sorry about that, class. I didn't hit the right thing. All right, let me just see. Oh, this is how I do it right here. All right, if you scroll down this right-hand side, you'll see a set of index cards for every chapter. The publisher has created a set of flashcards. Try to get them to come up. There I think it's starting to come up. All right, and this is kind of handy. I just wanted to show this to you so you know where it is. If this helps you, please use it. If it does not, just ignore it. All right. But for every chapter, they have every term from the textbook listed. Let me get to chapter 40 since we are in chapter 40. Oops. Oh, well, okay. So let me just flip the card. All right. So here's a term. I didn't identify this term for you to learn, but you can go through and pick through the terms here and throw out the ones that I am not requiring you to learn, keep the ones that I am requiring you to learn, and you can even create some new cards for yourself here. All right. So you can create a card using this feature down here. All right. So, all right. Want to end the video? All right. We'll pick up with chapter 41 in the next module. Let me just sign off now. See you in a bit.